Okay, I held off a little bit to see if anyone was going to make it, but it is now 7:12, and today is Wednesday, November 3rd, 2021. Welcome to week number 5 of Contemporary Issues in Criminal Justice. My name is Richard Wright, and I'll be covering the assignments for week number 5. And then coming back at 8:30 tonight to do week 6, um, because of the fact that the class actually ends a week from yesterday, the 9th. So you'll have both weeks already, okay? And in fact, I think that you'll have the announcements as well. So let's share my screen so we can get started here. Okay. So let's take a look at the calendar for the time for this week, the month. As you can see, this is where we are. You see 2 lectures here. But right now we're at the 7 o'clock week 5. And that your initial post was due yesterday, the 2nd. And your reply post is due Saturday, the 6th. And then your assignment and live lecture phrase is due on the 7th. So you'll be able to have that. And then you'll note, of course, that the course ends 2 days later, the 9th. We'll talk about that in the very next lecture. Okay. Let's look at the posted announcement. Okay. Week 5 announcement. We're talking about criminal procedure. To prepare for this, complete the activities, purpose of law, foundations of criminal procedure, and steps in the criminal justice process. I remind you to, in this, that the lecture is 7 p.m. and that I highlighted the second lecture that will be coming up at 8:30 p.m. Central Standard Time. And then the discussion assignment DNA submissions, we'll talk about that tonight, due on Tuesday. That was yesterday, the 2nd. And that reply posts, of course, are due as normally Saturday, 11:59 p.m. And then your written assignment, warrantless searches, which we've been talking about this term, are due this Sunday along with the key phrase. And then you know my motto, adversity is the springboard to success. Okay, so let's delve into the module 5 topic, criminal procedure. First, let's show you the written assignments. So you have 3 scenarios. Warrantless searches, as you discovered, are like one of our important um, tools that we deal with, but you must know the exceptions. And you're going to read these scenarios and determine based on the lecture notes in this module whether you as an officer would be permitted to conduct a warrantless search. Now, I will show you the lecture notes. So you're going to look at each of these. And so in a 2 to 3 page paper, explain the basis for justifying each of the 3 warrantless searches you read. For each, I'll give the reasons why the officer would be allowed to conduct a warrantless search or why the suspect's rights were violated by the warrantless search. This is an APA, citations in the body, and a reference page as well as a cover sheet. So you know already how that works because we've been doing that for a while in this school, and it is a Word document. It is not a PDF. It is not any other format. Okay. So let's take a look at the rubric. So here are the levels here. Scenario 1, your clear and comprehensive justification for the warrantless search or explanation of why the suspect's rights were violated, offering reasons in support. Remember, you got to have credible sources to support your position. So that's for each of these scenarios, okay? And you already know that it requires you to have APA. So if you don't have the sources to support, you're going to end up over here with unclear, unclear, unclear. So it's very important for you to do that. All right. All right. So now I'm going to show you what we'll do first. This one. So this topic of DNA, you're going to deal with the fact pattern reading here, and you're going to look at the 2 sources below. Okay, collecting DNA from arrestees. Make sure that the link is working. I'm pretty sure it is because we checked it before. Let's make sure. Yep, you don't have to deal with this. And so here's the actual article itself. You can download and print it, and it explains it. Okay. And then your arresting DNA laws PDF. Click this and download these. You can read this as well. And this is across the country dealing with various cases and case law. So you have enough material to help you with the discussion assignment. Okay. Then your live classroom recording. Okay, now let me show you. Here we go. So dealing with the purpose of law, foundations of criminal procedure, and the steps in the criminal justice process. Okay, very important. All right, so let's start by talking about what is the purpose of law. Okay, going back to, I mean, way back, I'd always ask my students when I first started teaching at Rasmussen, what is another word for laws? And the word I was looking for were rules. And the purpose of it is to maintain order and so that we can operate in a civilized society. And so dealing with criminal law and other laws, um, when you work with the government individuals, there are statutes or criminal codes that determine what the behavior is in the state as well as the federal laws. And we'll talk again, elaborate in just a minute. And the key thing is to um, make the system operate fundamentally in a fairness way. All right. And so when we apply the laws, that's what we call criminal justice, administration of justice. So there are four parts to it. There is the law enforcement, that is an investigative. That's the police. That's who you initially would come in contact with in the criminal justice system, of course. And then they gather up the evidence and then pass it over to the prosecution, who represents the people of the jurisdiction. And then it goes to the adjudicative aspects of it, if there's enough evidence, or courts, or either plea deals. As you know, that uh, only 10% of the cases go to trial, 90% go to plea deals. And if a person is found guilty or pleads guilty, then they go to the next phase, which is corrections. And corrections can either result in probation or jail or prisons. Now, um, you should be aware that it can be parole also, but probation is when you don't go to jail at all and you're assigned to a probation officer to give you an opportunity to um, correct the error that you made. It'll be a combination of factors. It might be education, or it might be providing a trade or something along those lines. Jail, you know, is for misdemeanors, uh, uh, crimes that you're sentenced for less than a year. And of course, prison is a year or more. And then you have the appeal, which automatically is requested by a defendant if there is a finding of guilty that you're not pleased with and you don't accept it. So you could go to the appellate court, and usually it starts out in what's called the appeals court. Then it goes to what they call the Supreme Court of the states. And then it can possibly go up the ladder all the way through the United States Supreme Court, which is the highest court in the land. And so they all of these um, agencies or aspects work together. The components work together to uh, provide what we use in our society to apply the law. Okay, and the Constitution requires that it be applied fairly. We'll elaborate on that in just a minute. Okay. All right. So I'm not going to go into that last paragraph except to say there are details that the individuals who work in have in terms of operating, and that, for example, as it says at the end, the police are tasked with enforcing and arresting law violators. The court-appointed public defender works vigorously to defend and release the offender, or a private attorney, one or the other. And so the key thing is that the United States Constitution and the Bill of Rights is what we apply. The United States Constitution has the first 10 amendments of the Constitution are known as the Bill of Rights. And generally, in our criminal justice system, we deal with the we could deal with the Second Amendment that involves, but that's really more individual constitutional. But when you get into the criminal system, you deal with the Fourth Amendment, which is the biggest part, dealing with search and seizure. And you spend most of your time as a law enforcement officer dealing with making sure that you don't violate the rights of individuals in that area. Remember, you can only search upon the issuance of a warrant, and the warrant is issued by the presentation of an affidavit before a judge, along with a issuance of a warrant, whether it's the arrest warrant or either the search warrant for property or something, that's some evidence. Okay, but so you can defend yourself against these charges, and that says you're not deprived without the ability to offer a defense for their actions. Okay, very important. So our rights are outlined in these bills, and I already talked about the Fourth Amendment. Very, very, very important. So now we're going to turn to occasions where you don't have to have a warrant, and we call these exceptions. And these exceptions are pretty explicit and clear. There are leading cases that have to do with these warrant requirements. They got some typos in here when they put this together. Exceptions to the warrant should be WARRANT. I didn't do this. Whoever set up this course material did that. So anyway, let's talk about consent searches. It must be voluntary and not under duress. There are third-party consents that are granted under certain circumstances, and these are listed here, right here, where it says that consent is valid if the third person has equal authority over the residence or the business, and it can be concluded the absent person assumed the risk of the cohabitant or roommate or partner might allow a search. Okay? Consent to search is not allowed if the cohabitant or roommate or business partner objects to the consent, even if the other person gives permission. Consent must be given by both parties if present. And the reason for that is because the other party has a vested interest in that itself. It may uncover some crime that the other party who's not present has committed. Parents may consent to search a child's living area if the parents have routine access to the area, or the child is not paying rent. That would generally apply to all minors. Okay, and it could apply to some adults that, like I have a son who lives with me who is 21, and that would apply there. I could consent to a search, as well as a son I have who's 26 who has his own room, because he does not pay rent. Landlords cannot give consent to search if there is a rental lease. Okay, so your landlord can't do it. Now, the key thing in consent searches that you should be aware, as I said, I go back to the start, voluntary. It could be written permission or consent. It could just be verbally. Can I search your place? And the answer is yes, then given. In that case, then it's consent. But it must be freely and voluntary. It cannot be a situation where the person is placed under duress. Let's say, for example, if a police officer came to your house and there were a bunch of them and they surrounded you and asked for your permission to search, that would not be deemed voluntary consent because you'd be placed in a situation where you wouldn't feel free to say anything other than yes. So it has to be uh, consensual. Okay, get that clear. Very easy to determine. Exigent circumstances. These can occur when um, there is a belief that if you had to go get a warrant, that the person could escape, or evidence destroyed, or there could be harm to someone. Um, Exigent circumstances, officers are allowed to enter a home when the suspect runs into the home or retreats um, into a private area and there is a reasonable fear of escape, destruction of evidence, or injury to the police. Such as we've had situations when I was a police officer where we were chasing someone and they ran into the house and we continued after them. We didn't have to stop to get a warrant to search in the house for them. And they went into the bathroom. We were able to go into the bathroom and recover the evidence that sometimes people were trying to flush down the toilet. Usually that was cocaine or heroin, something like that. So what the court looks at to determine exigent circumstances is, was it a serious offense or one of violence? Was the individual armed? They don't have to be, but these are just some considerations. Was the probable cause strong enough to believe the suspect was the one who committed the offense? Okay. Was there strong probable cause to believe the person was actually there on the premises? Did the police identify themselves and give the suspect a chance to surrender prior to entry? Was there an ongoing investigation or decision to arrest prior to the suspect fleeing into the premises? And exigent circumstances also exist, finally, if the police are responding to a domestic call. One of the most dangerous calls that we as police officers face is a domestic violence call, because someone's health, welfare, or safety is involved. But the reason why it's dangerous to us as law enforcement is, I can tell you there have been occasions, and I was involved with one at least, when working as a police officer, where the person who called us, the wife, whereas we were attempting to handle the individual who was the husband, and she uh, didn't like the way we were handling, and in one occasion sought to get a weapon to use on us. So we're you'll be surprised. You'll be surprised at those kinds of things. I witnessed myself as a kid, my mother having this live-in boyfriend that, and if you listen to my story, you heard me talk about it, who beat her profusely. And I remember the police coming, and they said, she said to them, "Don't hurt him, don't hurt him." Well, she was bleeding or seriously injured. The house was in disarray, yet she was still defending him and willing to defend him. She didn't take any actions like grabbing weapons or things, but those are all potential circumstances with domestic violence cases. Excuse me. Open view. Now, let me explain the difference between that and the next one. If an officer sees contraband from a vantage point that the public could view, such as if it's in a parked car, okay? Uh, if an officer is putting a parking ticket on the vehicle and notices a bomb or something that they suspect might be drugs, they can go into the vehicle without a warrant, okay? Now, some might say, well, that's plain view. Well, it's more bodacious than a plain view. It's just open, um, where the public could view. So let's say, for example, if you could see through a window and you can see something like that in a house, would you think that you might need a warrant to get it? Probably not, because of one of these exceptions. So let's talk about the plain view. That's the one almost everybody's popularly involved with. If an officer is conducting a lawful traffic stop with probable cause, or in a home where you entered for a lawful reason and sees contraband, then it may seize the contraband. That's the same thing I was talking about a few minutes ago. Okay. So in what we call plain view, you don't have to do anything to see it. The pat down frisk, uh, the name of this is what we call the Terry stop. You all have Terry versus Ohio, a landmark case that established the old stop and frisk. And the point of it is that you're supposed to pat down the individual for weapons or other items that could be dangerous. And it is strictly for the discovery of weapons. And generally, the pat down is limited to outer clothing. In addition to the basis for the stop itself, the officer must have had, they don't just at random stop somebody. They had to have sufficient basis. Then they look suspicious. Well, you got to make sure that that is applied properly. Sometimes people look suspicious to people because of their race. Then in that case, we might have a problem here. But let's say they look suspicious because they appear to be nervous in a situation, or you might ask them questions like their name and stuff like that. But the officer must have, as it says, sufficient basis to believe that person could possibly be armed, and able to articulate that for their safety that they conducted that search. Some examples: prior knowledge that the individual carries a concealed weapon, suspicious behavior such as failure to comply with instructions to keep hands in sight, like for example reaching into their pocket when you tell them to keep your hands in sight, observations such as certain bulges consistent with carrying a weapon, or prior knowledge that the suspect is a verified member of a gang known to carry weapons, and the behavior warrants. And notice they use the term that I said earlier, the Terry stop, Terry versus Ohio. The next one is search incident to arrest. Now, the name tells you a person, officer may incident to a lawful arrest, search and arrest these person and the area within their immediate control. It has to be in their immediate control, such as the area in which the suspect arrested, such as the home or vehicle. Now, search incident to arrest does not, if you get arrested in the kitchen, does not apply to going through the bedrooms and going in through the drawers or opening the refrigerator or things of that nature. It has to be an area where they have immediate control. All right. Custodial search. That, of course, applies that the person can be searched thoroughly when they are arrested or taken into custody. And this can be as soon as the person is under arrest and before transporting the person. So how do you know when a person is in a custodial status? I have said this before and I'll say it again. It does not require the words "you are under arrest." It simply requires that the liberty of that individual is taken away and that individual is not free to go. So one simple question that we oftentimes tell people is ask, am I free to go? And if the answer is no, then you're in custody. Okay. Evidence of any crime which is discovered in the course of a valid custodial search may be used to support whatever the subsequent charges. Let's say, for example, you stop a person and you discover a weapon on them, and you doing it for a Terry stop. All right, so then you can take that weapon, and then that person, unless they're authorized to carry that weapon, will then be said you're under arrest or under arrest. At this point in time, then you can then take that person, and they can be checked for other items. Let's say you find drugs and big substantial amounts of cash, um, or either bullets or something that relate to that. The point of the matter is that would be legal. Okay, so those are the exceptions that are involved here. Okay, and then these are a few articles about that. All right. Foundations of criminal procedure. Okay, you've seen this picture before. I'm well acquainted with this picture. That's also my favorite approach. Notice the jurors, they're all paying attention to him. Excuse me. And the reason why they're paying attention to him is because he holds their attention by telling them something. All right. I was very good at that. I had over 90% of my cases where I got not guilty verdicts. I mean, high 90s. It wasn't just 90%, it was like beyond 95%. So, so anyway, that's the picture of what it looks like there. Um, that right there, sitting at the table, is probably the prosecution. For two reasons I know that. Number one, being a lawyer for many years, usually the defense attorney and the defendant sit further away from the trier of fact, and that the prosecution, who has the burden of proof, sits closer to the jury. And I pay attention to that when I watch movies and TV shows and things of that nature. So, and then there's a safety issue too. So think about that. It's little common sense stuff that you could miss there. So I'll just point that out to you. So now let's talk about the foundations of criminal procedure. Um, as I had already talked about the Constitution itself. However, in every jurisdiction, including the federal jurisdiction has 18, that's the site, 18 USC, and then whatever the section of the statute is in USC. USC stands for United States Code. And then you'll see sometimes USCA. What that means is United States Code annotated, which, as you're familiar with annotations, that means cases that have, or rulings that have been dealt with under the section there. So criminal statutes, um, there may be exceptions, but most crimes have three elements. Three elements. What we call the act of the crime, or the actus rea, the mental intent to commit the crime, mens rea. Those of you who saw Legally Blonde uh, heard Elle Woods trying to explain mens rea to the judge, but all it means is the action, the mind itself, and then the concurrence of these two, meaning that the order that an individual uh, to be accused must have had the intent to commit the act. So it must be the intent. There's some specific intent, laws, and then there's general intent laws. Okay, and so it is what we use in our legal system to recognize that there are other things involved to understand crime, such as the cause of it, resulting harm, the legality reason for the law, the punishment principle aspect of it, and the attendant circumstances, the circumstances themselves. All right. So now, what are the elements of criminal procedure? So we have these statutes and rules that we apply in terms of conducting trials or dealing with the rights of individuals that regulate and control the court aspects of it. So all states, local municipalities, and federal government have their own codes. I already told you about that. And they set out how the law operates in their jurisdiction. Now, none of these should violate the Constitution, specifically the Bill of Rights. None should. Okay. And you should be aware, and I'll say this now, that the First Amendment deals with freedom of speech, the second with guns, the fourth, I'm skipped the third, but the fourth deals with search and seizure. The Fifth Amendment deals with self-incrimination. The Sixth Amendment, speedy trial and right to counsel. Those are the primary. So the primary ones are 4, 6, and then we have 4, 5, and 6. And then the eighth, I should say, is dealing with cruel and unusual punishment, and also issues like the death penalty or the conditions in which a person is held in custody. So we deal with each of these based on here with the seizure of property, self-incrimination. I already told you the right to have an attorney, excessive bail. That's the eighth. The speedy trial by jury. That's back to 6, and then the eighth. So they kind of mix them up here. We have what we call the exclusionary rule. The exclusionary rule. And this has to do with the biggest portion, as I said earlier, part and parcel, the Fourth Amendment search and seizure. And you're protected against unreasonable search and seizure and illegal searches that are presented can result in the evidence that is obtained being excluded from use in trial. And that's done by what we attorneys use in the pretrial process called a motion to suppress. And what we do is we present evidence or make arguments that say, for example, that the Fourth Amendment, the search was unreasonable. There was no warrant, and it didn't fit under one of the exceptions. That's the general part of it. And then, as far as interrogation and confessions, the Fifth Amendment protects against that, as you already know, the infamous Arizona Miranda versus Arizona case um, decided the Miranda warnings. You know how that works. And the arrest interrogation is Miranda. And I shared before that I had a professor whose techniques were pointed out as unconstitutional and violated the Fifth Amendment of the Constitution, and called out in the Supreme Court's case itself. If you ever read the footnotes, his name is Fred Enbow, and he had a partner by the name of John Reed, R-E-I-D, and their book that they used, that the departments used, was Interrogation and Confessions by these two authors. So in that, you know, the Miranda rights, you have the right to remain silent. Anything you say can and will be used against you. You have a right to an attorney. And if you can't afford one, one will be appointed to you. Do you understand these rights? So that's a general uh, survey of what it is. And you don't have to talk to the police. And if you choose to have an attorney present, uh, and you can't afford one, one will be provided through the public defender's office in those kind of situations. All right. So understand that all your rights that you have, as it says in bold print, are open to interpretation. And for example, in the Sixth Amendment, uh, the landmark case of Gideon versus Wainwright, 1963, which I really wish they would put the full citation, because that's what I require you to use when you use court cases in my classes. It became clear that the individual, before they were incarcerated, liberty taken away, that they needed counsel. Gideon defended himself. And so since Gideon versus Wainwright, the 63 case, it's now quite clear that when a person is going to be possibly held in custody, that they have a right to have what we call effective counsel. And some people don't think that, but what I'm about to say is true, but it is, that public defenders are good lawyers as well. Probably the biggest issue that faced the public defenders is the load that they must have and have to move them. And because of the Speedy Trial Act, they have to make sure that they're on top of representing those individuals that they do. So we have what we call the rules of evidence. The federal rules of evidence is patterned by every jurisdiction to deal with evidence that is admissible. And the guidelines are in written form, so you can see them. Um, for example, hearsay evidence is generally not admissible except if there are certain circumstances. I'll give you an example. It is believed that a person who is dying issues a statement about an individual or someone who did it, and we call these dying declarations. And it is believed that that person is about to meet their maker or about to pass, and they have nothing to lose. They're not going to lie, and in most cases, um, and the individuals will find in criminal cases that those statements are generally admissible, or as some people said, testifying from the grave. And it's argued by defense lawyers that you can't cross-examine those individuals. However, the argument must be provided that there is no jeopardy to the defendant because the information is pretty credible. And so that's just one example. There are others. So it must be quite clear that the evidence that is presented um, is does not violate the constitutional rights as outlined by some of the things I've said already, and convinces the judge or jury that the information is accurate and true. For example, the prosecution represents the state and the defense attorney represents the accused. And even though the court system is considered adversarial, pay attention to this statement, the court mandates that advocates for both sides do their best to offer possible defense to their clients as much as possible. And if the defense attorney considers their client guilty, still must provide the best defense. People used to ask me, have I ever represented a guilty party in a criminal case? And the answer is no, because I would answer this by saying that the judge or jury determines the innocence or guilt of that person. I did not do appeals. If I was doing appeals, then I could say that. But generally at the trial level, the statement is, and there are certain cases that we don't touch. Like, for example, I couldn't do domestic violence cases and defending people for obvious reasons. I could not do rape cases very well because I had nothing but sisters and no brothers and daughters. And then finally, later on in life, I got sons. So I couldn't do those. But I could do drug cases. I could do other kind of cases as well. So I didn't take them. Some people criticize adversarial process, say that there are many differences between law and science. Well, as we already know, that technology and science have come up with things like DNA, which I thought that revolutionized uh, the criminal justice system. When I started out in '78 and started working with lawyers, even in 1969, before I went to law school, where I had exposure to criminal cases, working before I became a lawyer in various forms, uh, just sometimes a tag along. But then when I became a law clerk, which is called a paralegal today, I got heavily involved just before I went to law school, 2 years before. Well, so the technique of DNA came about, and it provided a way to nail that person, because the DNA, if it's used properly, if it's not mixed up, if it's preserved properly, if the chain is maintained of the DNA, then it's very valuable and is used quite frequently to exonerate individuals for crimes. Fingerprint analysis is really sophisticated. No longer do you put your fingers and roll them the way that we were doing it first in ink on an ink pad. Now, because they use computers, you put your fingerprints and you do the same thing, but there's no ink or nothing that gets on there. And the technique is even much improved because of technology. Surveillance and other evidence, such as cameras, videos, and things like that, are helpful, such as interrogations in many departments now are required to be videotaped. And the reason for that is to, first of all, number one, the police should be uh, interrogating that person without violating their constitutional rights. But secondly, it takes away the argument in most cases that the person who conducted the interrogation violated the individual's rights, maybe forced it or coerced him. So, all right. This is the Gideon versus Wainwright. There was a great movie called Gideon's Army. I think it's called, yeah, I think that's the name of it. Anyway, that I have in a movie. Henry Fonda, I think, played that role. All right. So now let's deal with the concluding. We're a little bit over, but I'm going to give you this, and this is pretty fast. The steps in a criminal process. So, of course, you have speedy trial, impartial jury, and you also receive what we call uh, discovery, where you just receive evidence of what the prosecution has in order to substantiate the charges that they put out on you. And assistance of attorneys, we talked about that. So the steps in the criminal process start with the actual arrest itself. And the first appearance is generally at least 24 to 48 hours after arrest, depending on the processes and jurisdictions. And the formal charges are provided to a defendant, and the individual is given the opportunity to retain an attorney. If they can't afford one, then the court appoints a public defender. And then there's bail, and bail must be reasonable based upon the crime history of the individual, the nature of the offense, and things of that nature. Okay, there's bonds that can range from dollar amounts to where a person also has what we call a recognizance bond, also referred to as an I bond, where a person is released on their own recognizance. Those are people who don't present a threat to the community and generally might not have the ability to be able to post cash. Bond is posted in the form of cash or property. People have put the titles up to their houses and cars and things of that nature. Pledge stock, all kinds of things. So, all right. So the McNabb case set that standard. The second step is what we call a preliminary hearing or a grand jury. Now, the preliminary hearing is one that we as defense attorneys favor. However, in many jurisdictions, the prosecution has the right to go to the grand jury to determine whether there's enough evidence to take to trial. Now, the grand jury is heard, and why we defense attorneys don't like it is that we don't have input in that process. So if an indictment is returned by the grand jury, then the case is referred for trial. However, some states, there would be a preliminary hearing, which we love, where a document called an information is filed and determines if there's probable cause to bring the defendant to trial. So after the indictment has been returned or information filed, then we go to arraignment. And arraignment is really serves two purposes. And then either you're going to plead guilty or not guilty. That's it. If you saw my cousin Vinny, you know what I'm talking about. So there's only two answers, one of two answers you give. Okay, if the person says not guilty, then it goes to the next where we're going to talk about. If the person says I plead guilty, which very rarely happens, then you begin to go through what we call negotiating or the plea bargaining process. So it says defendants and their attorneys will normally agree to a plea deal if they're not sure about their ability to win at trial. Likewise, the prosecutor will offer a plea deal if they're unsure of their ability to win. And look what it says. Plea deals are commonplace, and as many as 94% of state cases are resolved through pleas, the infamous plea bargaining that the public doesn't understand. And it's important because we don't have enough resources to get individuals to trial and through trial without possibly violating the Speedy Trial Act, which jurisdictions have their own. If a defendant enters a plea of not guilty, then the case begins. And then the individuals, first thing they do is go through what we call voir dire or jury selection. And we have challenges that are given to us called peremptory challenges. These are challenges that we establish that come out of questioning the individual, or challenges for cause. Um, or challenges for cause is that we present a reason for that. With the peremptory challenges, we can use them without giving any reason, except we can't use them for to stack a jury racially. I could elaborate on that more, but just generally the statement made. And then the last one is challenges to the array. That is saying that the panel in it as a whole, looking at it, does not represent the cross section of the peers of that individual. Okay. All right. Not challenge, not of the community. Once the jury is selected, opening statements are made, which are not evidence. These are just what you intend to prove. The defense attorney gives one, and the prosecution both give them. And then it goes into the trial itself. The three types of evidence. There's direct evidence, there is circumstantial, and real evidence. Now, direct evidence proves a fact without requiring to any conclusion. Okay. For example, a statement made by an individual. Circumstantial is indirect and requires conclusions to be drawn, which are closer to what we find in most cases. We have some direct, but circumstantial. And then what we call real evidence, which consists of physical things such as tire marks, notes, fingerprints, DNA, and so forth. And people who are experts are often called when you deal with some of these types of things, such as fingerprints, DNA, and weapons. Weapons themselves are real evidence. So if using the gun, that finding the gun as an exhibit. Once evidence has been submitted and examined, they're ready for closing arguments. The parties rest, and the closing argument is given. The defense attorney gives the first one. I'm sorry, the prosecution will give one, and the defense attorney will go, and then the last one is the prosecution. So the defense attorney presents their statements first, followed by the prosecution. After closing arguments are complete, the judge issues what we call jury instructions that are written out, and these are for the jury to determine the elements of the offenses for which the person is charged. And then the jury deliberates, and in deliberation they select a foreperson, and the verdict must be unanimous. If there is not a unanimous verdict, then the jury is considered as hung. Okay. And so that's it for the criminal justice process. Sentences can be imposed by a judge and normally occurs at a later date. Doesn't usually take place right then and there. All right. That's it. So what are we going to do as far as dealing with the key phrase? Criminal procedure. That's the phrase to get your points. Give me criminal procedure, and you will have your points for week number 5. All right. So I'm going to see you guys in right around 8:30, 8:40 for the week 6 lecture to conclude the course. So I'll see you in a little bit.